Now on to round two, and round two is where the debaters address one another and take questions from me and from you in the audience. We have two teams of two. The motion is the constitutional right to bear arms has outlived its usefulness. The team that's arguing for this motion, that it's outlived its usefulness, Sandy Levinson and Alan Dershowitz. We have heard them argue that, number one, they're telling you that they're not here arguing to ban all guns, they're not here arguing to repeal the Second Amendment, but they are arguing that the right to bear arms has no place in the Constitution, that this should be left up to local governments and to states, that judges shouldn't be involved in making these policy decisions. They also are making the argument that the language as written really doesn't talk about a right to self-defense, that the right to bear arms is not the same thing as a right to self-defense. And if we want a right to self-defense, let us put it in the Constitution, but right now it's just not there. The team arguing against the motion, David Kopel and Eugene Volokh, are trying to get you to vote against this motion that the right to bear arms has outlived its usefulness. They say the right to self-defense is a basic human right, and so is access to the tools needed to carry out and execute that right. They say clearly that they believe that guns do deliver that self-defense and went through several examples of that. But they also say that it needs to be in the Constitution because there's a bigotry at the local level against gun ownership, and it needs the protection of a constitutional amendment, much in the same way as civil rights have in the past. So that's where the two sides stand on this, basically. And I want to go to the side that's arguing against the motion, trying to convince this audience that the constitutional right to bear arms remains vital, has usefulness, and to bring to you something that your opponent, Alan Dershowitz, said, in which he said, sure, you guys are arguing the right to self-defense. They concede that's a basic human right, but they also insist it's just not there in the language of the Second Amendment. It says right to bear arms, not the right to self-defense, and they say that's a difference. Which of you would like to take that on? Eugene Volokh.
Real quick.
David Kopel.
The Second Amendment is the right to keep and bear arms. As Heller and McDonald say, it's the right to keep and bear arms for all lawful purposes. Self-defense, hunting, target shooting, whatever. It's not limited to self-defense. Certainly self-defense is the most important purpose of that right under Heller. That's what the Supreme Court said was that the core purpose of the right, but the Supreme Court didn't say that was the only purpose of the right. The right is for all lawful purposes, and modern constitutions, state constitutions, say so more explicitly, but their point is the same as the Second
Amendment. Okay, so Alan Dershowitz, I think your opponent David Kopel is saying it's pretty obvious that's what everybody means by the right to bear arms, that it's the right to self-defense.
I think the Second Amendment historically gives the right of the people the right to use guns against their government. As Jefferson said over and over again, we need to have armed citizens in the state to make sure that there are no monarchies trying to take over. It was a right of revolution. There was no debate, as far as I know, about self-defense. It may have been implicit, but the Second Amendment's language, and many of the people who are the strongest supporters of the Second Amendment are literalists. They go to the original understanding. They look at the words. Why are you prepared to excise the first, whatever it is, 10 words from the Constitution? A well-regulated militia being necessary to the security of a free state. Are you prepared to concede that a well-regulated militia is no longer necessary to the security of a free state?
No.
David Kopel.
You want a revolution?
David Volokh.
Pardon?
I'm sorry,
no.
Eugene Volokh.
I want neither.
Huh?
I want neither. I think on this point the court was quite right. That if you look at the way the word militia was understood around the time of the framing, and actually remains a legal definition of the term, although not a common lay definition, militia meant the armed adult, at the time male citizenry, the times being what they were, and well-regulated meant basically well-functioning, well-trained. So really what they were saying is that an armed, well-functioning citizenry, well-functioning as a body that knows how to use its weapons, is necessary to the security of a free state, and that because of that, and this is a preamble that explains the rationale or part of the rationale for the right, because of that, the government shouldn't be able to disarm the people.
But
now,
was the point to defend the state or to defend your own home?
The point was both, and that is one of the things that the court, I think, correctly points out.
Alan, here's what you're overlooking. If you read things like Stephen Halbrook's The Founder's Second Amendment and the other intellectual sources, very clearly, they understood self-defense against a lone criminal and self-defense against a tyrannical government as the same thing, except the latter was larger in scale. It's all self-defense all the way up, all the way down.
So what does well-regulated mean? What you're trying to do is now say that everybody who owns an individual gun has to be part of a regulated militia. They have to come to the green every day and march and do.
Well, but they're not. But they're not saying
right?
that, Alan. They're not saying that. They're saying. I think what you're saying, and I'm not taking sides, but I just want to bring clarity to it. I think that's a straw dog. I think they're saying that implicit in the fact that if there were a militia, that the guys have the guns in the house, and they can also defend their house, and they need to have them to use them, whether the purpose was a militia or not.
But we don't have a well-regulated militia now. We don't have any kind of militia now. So I think you're conceding that the first part of the amendment has outlived its usefulness.
Thomas,
we win at least the first half of the debate, right?
David Kopel, and I'd like you to respond to what he just said.
Sure. Thomas Cooley, the greatest constitutional scholar of the latter 19th century, addressed your exact point, and he said that the interpretation you're following would defeat the purpose of the Second Amendment, because that would mean the government, by neglecting the militia, could thereby destroy the right to arms. We might have more public safety if there were something to encourage more regulated, well-trained citizen defense patrols, for example, in communities. But that's up to the government.
Like the Ku Klux Klan.
We can't force them to do that.
Let me bring in
but
Sandy.
The government's neglect does not destroy the underlying right.
Sandy Levinson, I want to return to this issue of the absence of an explicit right to self-defense in the Constitution. You would love to draw up the Constitution over again. You'd like to start all over, and if you did, would you write in, whether it's an amendment or in the body of the Constitution, would you write in a basic right to self-defense?
I would certainly consider it. It makes a lot of sense, but quite obviously, as I suggested in my opening remarks, it's a very, very capacious right. Does it extend to Martha Stewart, a convicted felon? And to me, it seems the answer should be yes. If Martha Stewart had knocked over a bank with a gun, I'm not sure I would say that she preserves her constitutional right to self-defense. What about non-U.S. nationals who live in the United States? Do they not bleed? Do they not have lives that are threatened? And then what about illegal aliens? The Fifth Circuit, as I'm sure Eugene and David both know, split 2-1 on whether or not a federal law that prohibits illegal aliens from possessing guns is constitutional. Their argument was that the point of the original Second Amendment, and I think they're correct, I didn't do adequate justice to Bob Rosenkranz's initial introduction. I think the historical origins of the Second Amendment really do have to do with citizen militias organizing to overthrow corrupt governments. And the argument was that an illegal alien isn't part of the American community politically, which is certainly true. That doesn't mean that an illegal alien has no right to self-defense.
The right of the people to keep and bear arms throughout American history has had a self-defense component as well. We see that in the Pennsylvania Constitution of 1776, which talked about the right of the people to keep and bear arms in defense of themselves and the states. Later on was more clearly even changed to each citizen defense of himself and the state.
But that wasn't put in the U.S. Constitution. They knew about that, and they didn't put it in.
But they talked about the right of the people to keep and bear arms. What you're suggesting is that the Second Amendment, you're suggesting the Second Amendment is obsolete in part because the framers used the term keep and bear arms there in a way that's different from the way that it was being commonly used in the coordinate state constitutions of the time. I think you're creating obsolescence of your own making. You're interpreting it in a strange way as saying, well, it wasn't intended to deal with self-defense, and now you're saying it's obsolete. Well, I'm saying it was intended throughout to deal with self-defense. It was also aimed at a means of deterring government tyranny. But the interest in self-defense has been always around. And if you look at court decisions of the early 1800s, all the time they
but
said
you're
that.
focusing on the wrong words. I'm not denying that the right to bear arms might have some current relevance as part of a right of self-defense. What I am arguing is the prelude to the operative words of the amendment clearly have become obsolete, a well-regulated militia being necessary to the security. Now, the answer that David gives is you want the deacons of justice to be able to come and have an armed conflict with the Ku Klux Klan. Now, I was in the South during the Civil Rights Movement. The last thing Martin Luther King wanted was to arm the people and the civil rights workers. He wanted to confront violence with peace. And a well-regulated militia would have included the Ku Klux Klan. They were the citizens. They were the ones who were worried about the government taking away their civil right to have a segregated community. And the answer that my opponents give is, if the Ku Klux Klan is armed, then we ought to arm civil rights workers, and let's have a war. I think Martin Luther King gets the better of that argument.
David Kopel, I don't hear them saying that or even coming close to implying that. Even though that was a great moment. But I want to let them respond to it.
Doing? Well, the point is that those who want, the majorities that want to oppress minorities, like the Ku Klux Klan with local police connivance, they're always going to have arms. And I applaud your presence in the South. You perhaps might not have been on the summer march from Mississippi to Memphis, led by Dr. King, where the Deacons for Defense were there and, in fact, were providing personal security for Dr. King himself.
All right, I want to move on to a slightly...
How did that end up for Dr. King? How did that end up for Dr. King? Not very well.
I want to move on to...
The availability of a gun.
I'm sorry.
I want to move on to another...
I don't understand what you're saying. The assassins are going to have the guns. The question is whether people ought to be able to have guns to defend themselves as well.
The assassins have an easier time getting the guns when they're easily available in society.
How do you propose making it hard for an assassin in a country... How do you propose making it hard for a political assassin who is willing to throw away the rest of his life, essentially, for his act, making it hard for him to get a gun in a country where there are 300 million guns?
That's the point. That there are 300 million guns. I want to live in a country where there are not 300 million guns.
All right. I want to stop this for a moment. I want to stop this. We're starting to turn into a gun control debate here, which is not precisely what we're doing. What we're trying to focus on is the function of this power being enshrined in the Constitution or not. And I want to return to that by going to something that Sandy Levinson said, where you basically were telling the other side that they don't really need to have this right enshrined in the Constitution and protected because the political process, as it is already tilting, I think was the word you used, towards increasing gun rights. And I want you to take 30 seconds to push that point, and then I'd like to hear the response from your opponents, because I think they said the opposite.
Okay. 90% of the American public, rightly or wrongly, but 90% of the American public thought that the Senate should at least take a vote on enhancing background checks. It never got to the floor of the Senate. Last night, I think the NRA invited people before the debate to chime in with their views, and I was told before we came out that the current vote is something like 43,000 against the motion and 700.
You mean on the Intelligence Squared website?
Yes.
Yes, we experienced a blizzard of votes.
Right.
And it's 46,000 against the motion and 700 for the motion.
And the strongest argument for substantive constitutional rights is when you believe that a vulnerable minority is likely to be victimized by what Americans learn to call the tyranny of the majority. Whatever your views are on gun control, at least right now and throughout most of American history, it is so wildly unlikely that however many people own the 300 million guns, because most people who own guns, I think, own multiple guns, that they are comparable to Jehovah's Witnesses, say, or some other vulnerable minority, that they need the special concern of judges basically to make up public policy for the entire country.
Okay, let's have. Actually, yeah. I'd like to hear from David on that, because you raised this point that in fact the constitutional amendment was required as a bulwark against the political process, and your opponent is saying that the winds are blowing so heavily in your direction that that's not necessary.
constitutional rights are not only for persecuted minorities. I don't think ABC, CBS, the New York Times, and the New York Daily News are comparable to Jehovah's Witnesses either, and it's very important that there be a strong First Amendment to protect them. And in Nebraska, where the right to arms is culturally strong, the Second Amendment is still necessary for exactly one of the issues you raised, the right of legal permanent resident aliens to obtain concealed carry permits to carry handguns for lawful protection as law-abiding American citizens can do. And unfortunately, there are, in this large and diverse country, just about anything that you can say is nationally popular is going to be nationally unpopular with some local group of people who don't celebrate diversity and respect all rights. And in places like New York City and San Francisco and Chicago, with their irrationally extreme anti-gun administrations, absolutely the Second Amendment is important
what would
to
the United
protect
States
them.
look like without the Second Amendment? Everything else being equal, I know that's awkward, but everything else being equal, if the protection weren't there, where would we be in terms of gun ownership in this country?
People in Washington, D.C. would have no right to defend themselves in their home against a violent home intruder, for
Even if they
example.
voted that way. This is interesting. We're hearing an
Dershowitz.
argument for diversity that would deny the people of New York the right to show their diversity by saying, we don't want to be like Montana. We would much prefer to have fewer guns. That argument is rejected in the name of diversity?
Diversity is not suppressing someone else's rights. That's no part of diversity. Diversity is respecting everyone's human rights fully.
And respecting them from a point of view of the majority prevails when you have different views and different cultures and different societies and different attitudes and different approaches. And if the people of New York City have a different view from your view, why should they not have the right to express that view and have it implemented?
Because
isn't there a right to a gun-free society as well? Why don't we have that
Is there a right to
Eugene
blasphemy?
Volokh.
Is there a right to a blasphemy-free society? Is there a right to a
No, because
contraceptive-free
blasphemy doesn't hurt
society?
anybody.
So, but the whole point of individual rights are that they are trumps on
Because, as
majority
Sandy
rule.
Levinson said, you need to have the right to blasphemy, otherwise the Jehovah's Witnesses will be prosecuted. The reason ABC and NBC have the First Amendment rights is we can't distinguish between them and the Jehovah's Witness handing out a leaflet. The basic right belongs to the Jehovah's Witness. The derivative right belongs to ABC.
I want to
That's
bring
the only
Sandy.
reason we have
hold,
ABC
hold everyone.
protected?
Sandy Levinson is much too polite for this debate, so I'm going to. I'm creating an opening for him, and you're to step through, Sandy.
I'm just a Texan. I think we ought to be aware that there's something strange. Again, whatever one's views are about gun rights in the United States, there's something strange in referring to them as a human right. Because, and here's I think where Alan's point comes home, it really is quite remarkable that among the roughly 190 countries or so that are currently in the UN, there are a grand total of 4 that recognize some kind of constitutionalized right to bear arms, and you discover that the Mexico Constitution allows reasonable regulation. So it may be, I mean, this is, again, a topic for a different sort of conversation. It may be that there is something about American culture that recognizes that it's a right within the United States. It's part of American exceptionalism, that guns are treated much more seriously than anywhere else in the world. But human rights arguments really do have a universalistic overtone. We talk about intervening in foreign countries because they don't recognize human rights. So does David suggest
but aren't
that
they
we
saying,
invade one or another of the 180
just for clarity on what
countries?
they said, they didn't say that guns are the basic right. They said self-defense is the basic right.
But guns are necessary for self-defense.
You know,
I think that's what David
Sandy,
is saying.
Eugene Volokh.
I don't think American rights should be obsolete just because foreign countries don't agree with
No, I'm
us
talking
on that.
no, I'm not making that argument. I'm simply talking about nomenclature. That it's one thing to say we in America are committed to certain rights, some of which look very, very odd to the rest of the world. We could talk about hate speech in this context, and you and I both agree that hate speech is protected by the First Amendment. Most countries around the world don't protect hate speech, and they're decent liberal countries who simply have a different understanding of what free speech means. All I'm saying is that an argument based on the particularities of American culture is very different from an argument based on
All
human
right,
rights.
David Copeland, you'd like to respond to that?
The United States is unique with its exclusionary rule against illegally seized evidence being used in court. We have much stronger rules against the establishment of religion than most other countries do. But I think the fact that many countries have gone away from what was traditionally their respect for much of their history of the right to arms and of the right of self-defense does not denigrate that right from existing at all as a human right. As the United States Supreme Court said, the right to assemble and the right to bear arms are both found wherever civilization
Which countries
exists.
have moved away from the basic right of self-defense?
Oh,
Name a country.
England.
Self-defense? You mean
In-
they
in
haven't
practice-
enacted stand your ground laws?
No, it means their gun laws are structured so that as a
I'm
practical
talking
matter
about
it's impossible.
self-defense. Great Britain common law provides for a fundamental right of self-defense. I challenge you to name one country that has abolished the right of self-defense.
England has gravely restricted it in practice. Fortunately, under intense popular pressure, they had some reforms a couple of years ago which restored some of it, but they have a principle of proportionality.
Of course they do,
Well,
and
no,
that makes sense.
No,
That's a
it
human
doesn't-
right, too.
Not as it works in England, because if you're a woman and a guy weighs 200 pounds more than you, was beating you to death with his hands and fists, under English law, you could only fight back with your hands and fists. You couldn't shoot that person because then you, the victim woman, would be escalating.
On the
That,
other
in
hand, the
practice, is destroying the
NRA
right of
proposes a
self-defense.
law whereby if you're in your car and can go from 0 to 60 in 1 second, somebody comes over to you with a knife, and you have the option of running away, you have the right to stand your ground, pull out your Uzi, and kill him in cold blood. That's the NRA's position on self-defense. There are absurd NRA positions on self-defense. There are reasonable,
All right.
nuanced, calculated
again, we're
compromises.
not debating.
I prefer the English rule.
Again, we're not
to
debating
Florida rule.
the NRA's stance on gun control tonight. But this point did come up in terms of the constitutional issue. I'm speaking now to the side that's arguing that the constitutional right to bear arms has outlived its usefulness. Your opponent said, well, you know, the Constitution, the amendment may be there, the right to bear arms may be enshrined in the law, but that doesn't mean that you can't limit gun control. That, in fact, the Heller decision specified all sorts of situations, guns in the hands of mentally ill people, felons, et cetera, that as it is, your hands are untied, in fact, to affect gun ownership laws in the United States. And I just want to have you respond to that and then hear what your opponent said to your response.
I agree with that. Most
Levinson.
Americans, if you poll them, believe, A, that there is some kind of fundamental individual right to own firearms, and B, that there ought to be reasonable regulation. So the question is, who ought to decide at the end of the day what counts as reasonable regulation? I believe precisely because there's so much difference, good faith difference of opinion, that this is, in America of the 21st century, a subject for legislative resolution. You won't like some of the particular solutions, but that's what federalism and political diversity is about. But none of us on this panel is arguing that the state can never, ever limit guns. And at least as a political preference, neither Alan nor I would support in the United States in the 21st century a proposal to ban any and all firearms. But we're talking about reasonable regulation and who ought to make reasonable regulation.
But they're saying that the existing amendment is not an obstacle to reasonable regulation.
Well, but there's a tension here because, I mean, for the first 200 years of our history, the Second Amendment really played no role in American constitutional law, if you define that as judicial decisions, especially at the national level. It's only been in the last 6 or 7 years that it's played any role. So the debate in part is, well, should the Second Amendment now really be invigorated so that 5-4 majorities of the Supreme Court will decide whether or not Martha Stewart should be able to have a gun for self-defense? And it appears, although Justice Scalia didn't offer even an iota of a reason, that he said, no, she doesn't get it. Or do you want these, say, hashed out? Either the Second Amendment really has some genuine bite to it, or it's an expressive aspect of the Constitution
All right.
as it was for roughly the first 200 years of our history.
I want to
first
give Eugene
10 years
Volokh
of
a
our
chance
history.
to respond, but after that I'm going to come to questions for you in the audience, and the way that will work is just raise your hand. I'll call on you. Well, a microphone will be brought to you. We'll ask you to wait until the mic reaches you so that the radio broadcast folks and the folks listening on the live stream can hear you. I'll ask you to state your name, and I'll ask you to ask a question that's focused on the topic tonight. Eugene Volokh.
So let me answer Sandy's point on work, and also a point he made about the background checks failing in the Senate, in the Congress. My colleague Adam Winkler at the UCLA Law School, who I don't think anybody would think is a hardcore NRA supporting Second Amendment maximalist, I think made a very good argument that the thing that probably most defeated background checks was the proposed ban on the so-called assault weapons, which are semi-automatic weapons that are really functionally not much different than other kinds of weapons, but they were singled out for specific prohibition. He said that poisoned the well. That after assuring people, oh, we're not going to come to take your guns, people say, oh, they are coming to take our guns. And that caused people to dig in. You're talking about the functions of individual rights. One of the functions of individual rights is to provide enough of a detente in these kinds of social battles, especially culture war battles, that a side could say, look, we're confident enough they're not coming to take our guns, that if what is on the table is a background check, it might pass, just as it has passed in the past. It passed in the early 90s. So that's actually one advantage that the Second Amendment, securing an individual right, but more specifically, the call of the questioner call is about the right to bear arms, specifically the right to bear arms being recognized as an individual right provides. If that were called into question, if that were repealed, or if people would say, well, we would repeal it if it weren't for our better political sensibilities, that's the sort of thing that would poison the well further. So if you want to actually get a background check passed, you're much better off with a Second Amendment respected and firmly recognized as part of our Constitution, and then questioned and said to be something that's ripe for repeal.